Good afternoon. My name is Lisa Soronen, and I'll be moderating this session. Welcome to the CSG eCademy webcast titled Federalism and the U.S. Judicial Branch. Charged with advancing the role of the states in America's federal system, the CSG Federalism Task Force is pleased to present a three-part civics education series. This, the third of eCademy events on federalism's impact across the branches, explores the United States court system, including the United States Supreme Court. Today's session will be recorded and posted in a few days to CSG Knowledge Center website. If you have any questions, type your question in the question box on the right-hand side of your screen. I will ask the questions at the end of the webinar. I am the first speaker. I will discuss how the United States court system works, focusing in part on the relationship between the federal and state courts. I am the executive director of the State and Local Legal Center. In this role, I file amicus briefs to the United States Supreme Court on behalf of the members of the Big Seven, including CSG, the National Governors Association, and the National Conference of State Legislatures. Our second speaker is Paul Clement. Paul will discuss how the U.S. Supreme Court works. Paul is a partner at Bancroft PLLC. He served as the 43rd Solicitor General of the United States from June 2005 until June 2008. He has argued over 75 cases before the United States Supreme Court. He graduated magna cum laude from Harvard Law School, where he was the Supreme Court editor of the Harvard Law Review. He also clerked for Associate Justice Antonin Scalia of the U.S. Supreme Court. So with that, I will begin. So Carrie, if you could turn to the next slide. So to learn more about the topic that I'm going to cover today, I want to recommend the following book, American Legal Systems, a Resource and Reference Guide. So when I was in my first year of law school, before school began, I was required to read a book, maybe about 100 pages long, that covered just generally how the court system worked. And it wasn't assigned for any particular class. It was just assigned so that all law students had some idea of how the court system works, because it wasn't really covered specifically in law school. So I tried to go back and find that book, but I was afraid to ask my mother to go through, our attic and remind her of all the boxes I have up there. So I was actually able to rent this book online from Amazon, and I returned it early, so it was basically a free rental. So if you're curious about this topic and you want to learn more, it's a great resource. So let's move to the next slide. I thought to make this presentation a little bit more real, I would talk about a real live case that's actually pending before the Supreme Court on a cert petition, which just means the court is going to decide sooner or later whether or not to take the case, because this case will illustrate some of the principles that I'm going to talk about. The case is called Los Angeles versus Contreras. It has rather outrageous facts by any standard. So Mr. Contreras engaged in a drive-by shooting. I don't believe he successfully shot anyone, but he ended up jumping in a car and engaging the police in a high-speed chase. At some point, he jumped out of the car, and police saw him reaching towards his pockets as if to grab something. And they told him repeatedly to drop his weapon, because they thought it was a weapon, and to surrender, essentially. He refused to do so, and they eventually cornered him at some sort of gate, and they ended up shooting him in the back. And so he sued, claiming that he was the victim of excessive force by police officers in violation of the Fourth Amendment. And so he won before the lower courts, which I'll talk more about later. And I'll talk about how this case has gone through the court system and has arrived, at least for the moment, before the Supreme Court. So keep that scenario in mind as we talk some more. So the next slide talks about how we operate in a federal and state court system. Basically, one of the best examples of federalism that our government provides is the fact that we have a federal court system and a state court system that operate simultaneously and mostly independently. It is the United States Constitution that gives the federal courts their powers. And all the powers that are not given to the federal courts essentially reside in state courts, at least as far as powers of the court are concerned. All right, so the next slide. If you're wondering where all this comes from, if you don't carry your pocket constitution to a session like this, you're probably never going to carry it. So if you pull it out, you can look to Article 3 of the United States Constitution, and it describes the powers of the federal court. But if you go to the next slide, this slide basically explains what those powers are. The federal court decides federal constitutional issues, federal statutory issues like the Americans with Disabilities Act, what's called diversity jurisdiction, which is basically two parties from separate states suing each other or one suing the other, where the amount at stake is $75,000 or more. If the United States is a party, the federal courts have jurisdiction. There's also some special topics like antitrust, admiralty law, maritime law. And then there's the concept of removal, where if a case starts in the state court, but a federal court has jurisdiction to hear that case, in other words, it meets one of these other criteria, then that case too can be removed from state court to federal court. So those are the topics where the federal courts can get involved and issue decisions. So the next slide talks about, well, what do state courts decide? They decide any other case, including those cases where the federal courts have jurisdiction with a few exceptions. So getting back to our scenario, you might wonder, is this a case, next slide, that could be heard in the federal court? And the answer is yes, because Mr. Contreras is claiming that his Fourth Amendment rights were violated. That's his right to be free from an unreasonable seizure, search or seizure, which he says he was subjected to excessive force, which is a violation of that. So yes, our case could be heard in federal court and was, in fact, heard in federal court. All right, so the next slide, I'm going to talk about what is the structure of the court. So the federal and the state court system, with a few exceptions on the state side, is a three-tier system. So the lower court is called the trial court, and this court decides facts, basically. The intermediate court hears appeals from the lower court, and then the high court hears appeals from the intermediate court. So go to the next slide, and I'll give an example of the federal system. So Paul and I are both from Wisconsin, so I thought it would be fitting if I talked about the federal court system or the structure of the federal court from the perspective of Wisconsin. So in terms of the federal court, the lower court is called the district court. This is the trial court. There are 94 federal district courts in the United States. And there are two located in Wisconsin, one in the Eastern District of Wisconsin and one in the Western District of Wisconsin. So the intermediate federal court, so the first level of appellate court in the federal system, is called the Court of Appeals. There are 13 of those in the United States, and the Seventh Circuit hears cases from Wisconsin, Illinois, and Indiana. Now the High Court is, of course, the United States Supreme Court, which Paul is going to talk about more. Okay, so if you go to the next slide, I'll cover the state court structure. So in Wisconsin, the lower court, the lowest court, the trial court is called a circuit court. And these in Wisconsin are organized by county. I don't think that's necessarily the case in all 50 states. So the immediate court, which is a court that I actually worked for as a clerk, is called the Wisconsin Court of Appeals. So in Wisconsin, there are 4 Court of Appeals that are organized by district. The court that I worked for was called District 2, and it was all the counties that surrounded Milwaukee County. Milwaukee County had its own appellate court, if you will. And then the High Court in Wisconsin is, of course, the Wisconsin Supreme Court. Now, interestingly, the judge I clerked for at the time had joined the court in '78. And '78 was when the Wisconsin Court of Appeals started. There are still a couple of states in the United States that only have trial courts and a Supreme Court. They don't have an intermediate court, but that's not usually the case. Now, a lot of cases that happen at the state level are not heard necessarily in all these courts. They're often just heard at the trial court level, sometimes in specialized courts. For example, the family court, the probation or the probate court, the juvenile court, those are all specialized courts within the lowest court system. Okay, so go to the next slide and I'll describe how our case proceeded, the Robert Contreras case. So like I said before, this case happened in federal court. So it started out at the federal district court level in the Central District of California. So when I say court, it's really just one judge that was presiding. So he held a trial, and Contreras won. I believe he lived, so it wasn't his estate that won. He won, and he got about $6 million. So then the city of Los Angeles appealed this, and this went to the U.S. Court of Appeals for the Ninth Circuit. And a 3-judge panel heard this case, and again, Contreras won. So the city has appealed this case for the second time now before the United States Supreme Court. And the appeal is pending, meaning the court has not decided yet whether or not it wants to take the case. Okay, so we'll go to the next slide. So the question is, what do courts decide? And this may seem obvious, but it isn't necessarily. Courts decide live cases or controversies. They don't decide anything else. And so if you go to the next slide, this slide describes or lists out some of the things or some of the instances when courts don't decide things. Some of these terms, even if you're not a lawyer or you don't have much legal knowledge, are terms you've probably heard before. You've probably heard at least standing and mootness. So these are doctrines that a court would rely on to say, you know, it looks like there's a case or controversy here, but there really isn't, so we're not going to decide it. So standing is, I'll just go through a few of them. Standing is the idea that a party has to actually, in fact, be harmed. My favorite case of all time to illustrate standing is the Newdow case. So around 2000, the United States Supreme Court took a case involving a man challenging the fact that his daughter recited the Pledge of Allegiance in school, and it uses God in the Pledge of Allegiance. And so case made it all the way to the United States Supreme Court, and the Supreme Court ultimately refused to decide whether or not this violated the Constitution on the grounds of standing. So here was the deal. Mr. Newdow and his wife both had custody, meaning decision-making authority over their daughter. But they had a history of not getting along. So Mr. Newdow's former wife had what's called bypass authority. So if the two of them could not get along, she ultimately could make the decision, even though technically speaking they had joint custody. So it's like he had 49% custody, she had 51%. And she was a Christian, as was her daughter. And she said, you know, I have no objection to my daughter saying the word God in the Pledge of Allegiance. So the court ultimately never decided that issue because they said Mr. Newdow had no standing because he had no ultimate authority to decide what his daughter's religious beliefs would be. Mootness is another one you hear all the time. Mootness is the idea that there was a controversy at one point, but the controversy doesn't exist anymore. My favorite case right now that maybe raises the issue of mootness is the Fisher case. Fisher was a student at the University of Texas, or she tried to be a student at the University of Texas, and she wasn't admitted. And so she challenged the affirmative action plan, and I'm guessing Abigail Fisher is now somewhere around the age of 25. She has graduated from college and is working. And so the idea that she still has a controversy with the University of Texas seems sort of absurd. After all, she's graduated from college and won't be going back there. But the Supreme Court has heard a case involving her, despite the fact that she graduated once already, and has agreed to hear another case again. So, you know, that's a case that sort of illustrates mootness, although the court isn't necessarily relying on it. Exhaustion and finality are sort of related. They're the idea that sometimes you have to go to administrative branch and have your dispute resolved there first. Ripeness is where you don't have a controversy just yet, but you might have one in the future. And political questions are when there's some dispute between the two branches of government that the court doesn't have the authority to get involved in to resolve. So every dispute in the world would not be resolved by a court because of these doctrines. And those are some examples of when a court will not get involved. Okay, so next question, or next slide. Do we have any controversy problems in our case? I would say no. None that I can think of, at least. So I'll move on to the next slide. So what do courts do other than, obviously, they resolve controversies? Well, most notably, courts issue opinions. So the next slide, I will say, what I will say is this. For those of you who are non-lawyers, maybe you've ever had an inkling to read a judicial opinion, or maybe you will after this presentation. They can be intimidating because they often, always really, use legal terminology. But if you can get over the legal terminology, some of them are enjoyable and interesting to read. If you had to ask me for one, I would recommend Riley versus California. You can Google it. And just read the Justice Roberts opinion. The issue in the case is whether police need a warrant to search a cell phone of someone who's arrested, or whether they don't need a warrant. So it's a very easy to understand opinion. Justice Roberts writes in a very easy to understand, funny, terse sort of way, especially in this opinion. So if you ever wanted to read a court opinion but you were intimidated, I would recommend the Riley opinion to you. So the next slide, how do courts decide cases, and how do they figure out what to say in their opinions? Well, basically, the idea is precedent. Courts rely on previous opinions in coming up with the opinions they write when they have a case in front of them. Okay, so the next slide will describe sort of two different ways that legal systems can be organized. One is a common law system and one is a civil law system. So the common law system relies on precedent, on past opinions. It leads to basically judge-made law, and it has roots in the English court system. The civil law system is an alternative system. It relies on codes rather than on common law. And I didn't know this, or I didn't remember it from reading the book, some 18 years ago, that apparently if a judge issues a decision based on a code, but the case goes beyond the code, that case isn't binding. And this system has French roots. So in the next slide, I pose to you, many or most of you who are legislators, are you surprised to learn that the United States has a common law system? It does not have a civil law system. Though we do have statutes in this country, obviously your legislatures, you write them, the common law system is the one that sort of predominates. So the next slide talks about the different types of case law. So there's some areas of the law that are entirely dependent on case law, entirely dependent on judge-made law from past decisions. The first case I worked on when I worked for the Court of Appeals in Wisconsin was whether or not someone could sue a police officer for emotional distress if a police officer shot her dog. And the only place to turn there is case law. Another sort of typical issue that would only be resolved by case law and is resolved in different ways in different states based on case law is if an engagement is terminated, who gets to keep the ring? So some issues focus more on statutory provisions, but even there, case law is important. I'll give you an example. Last term, the court decided whether disparate impact claims were possible under the Fair Housing Act. And how the court basically decided it is it looked at laws that had language similar to the Fair Housing Act, and how did cases interpret those laws? And that's basically how the court decided the case. And then in some instances, the court is looking at case law related to constitutional provisions. Last term, for example, the court had to decide whether or not there was a liberty interest in same-sex marriage and look to the case law that related to family law topics and how the liberty interest was defined in prior cases, basically to come to a decision in that case. So the next slide talks about what case law applies to our case. Well, our case involves purely a constitutional question. It's whether or not excessive force was used in this case. But there's plenty of case law. Well, maybe not plenty. There's enough case law that defines what excessive force is. And actually, I had to update this slide yesterday to make it accurate. And that is to say that yesterday, the Supreme Court issued its most recent decision in an excessive force case. So the court may, when it decides whether or not to take the Contreras case, it may look at, or if it does take the case and actually decides it, it may look to the Luna case to decide the limits of how it's looking at excessive force these days, or I guess rather probably qualified immunity. So the next question, or the next issue I address is what exactly is the law? So I have the law listed here in the order of importance. So the Constitution is the most important law. It's a law that governs all other laws. Statutes, executive orders, cases, etc. cannot contradict the Constitution, at least in theory. The second most important law is statutes. And then it's followed by rules and regulations, executive order, and then case law or common law. The next slide, I have written down who comes up, who is the author of the various kinds of laws. For example, statutes are written by legislatures. Rules and regulations are issued by administrative agencies. And executive orders, of course, come from the president or governors. And it's judges exclusively who issue case law or common law. So you have some appreciation of how our federal system devise the authority to make laws. Each branch has some role. Okay, Carrie, it looks like we've gotten a little bit behind, so I'm actually 2 slides ahead of you. So the question, our next question is, what law applies in our case? Well, this is purely a constitution. It simply involves the 4th Amendment. But remember, the 4th Amendment is also defined by case law. So any court deciding this case would look to the 4th Amendment and then, more significantly, practically speaking, to the case law that defines the 4th Amendment. Okay, my next slide discusses how does a law develop. It basically develops through an ever-expanding body of precedent. Every time the court issues a new decision, the law develops more. Now, precedent has rules. Basically, how precedent works. If the same level or a higher level of a court in the same jurisdiction has issued a decision, that decision has to be followed. That's how precedent works. And the principle is called, in Latin, stare decisis, which means let it stand. So why have a system, next slide, of stare decisis? Well, there's a couple of reasons. It saves judges time from having to reinvent the wheel every single time. It leads to more predictable results. It leads to more fairness to the parties, as different parties get the same results. And it's also a check on arbitrary behavior. But the disadvantage to stare decisis, of course, is what if a case was decided sort of poorly to begin with? And then you keep on relying on it and relying on it and relying on it. That can be bad news. Okay, so the next slide explains when precedent applies. Like I said, if you're in the same jurisdiction, precedent would apply. For example, in the Seventh Circuit, which I talked about before, if the Seventh Circuit had previously ruled on an issue, precedent would apply there. If a higher level of court has ruled on an issue, then precedent applies there. Now, there's binding precedent or persuasive precedent. And precedent is only binding when a higher level court has decided an issue in the same jurisdiction and the issue is factually similar and applies the same law. But it's important to remember that the Supreme Court its decisions apply equally to state and federal courts. Okay, so an interesting federalism pointer here about the courts. State courts are not bound by an interpretation of federal law that has been issued by federal district court or federal court of appeals, even in the same state. So to give you an example, a federal district court in Wisconsin or the Seventh Circuit issued an interpretation of federal law. The Wisconsin state court is not obligated to follow that decision. And the reason is because, like I said, largely the state court and the federal court systems operate independently. So the Wisconsin state courts can interpret the law as they like. Okay, so the next slide talks about the fact that the reality is, in many instances, there's no precedent that's a perfect fit. All cases have at least slightly different facts. And so what are courts to do about that? And that's really why I guess we have all the case law we do, is because very rarely are cases identical or the same. So what happens is courts look to other decisions, even if they're not binding, and rely on them regardless. And they look to different criteria. For example, is it a jurisdiction that the court respects and likes? Is it a higher court that issued a ruling on a similar issue? How similar are the facts? Is the reasoning attractive? Is a case a court might want to rely on really old, or is it been decided more recently? Those are some of the criteria. So the last point I'll make about stare decisis is that, like I said, and you can go to the next slide, Carrie. Like I said, stare decisis is a bedrock principle of every court, the Supreme Court included. But that's not to say that sometimes the baby doesn't get thrown out with the bathwater. And there is a case, this term in particular, where the court might sort of dump stare decisis, and that's Fredericks versus the California Teachers Association case. The question is whether or not what's called fair share or agency fee violates the First Amendment. This is the principle that even if you don't join the union, you still have to pay most of the union dues. Since 1977, the court has said that that's constitutional. The court has built a body of case law around that holding. The case is called Abood. The court is widely predicted to overrule Abood, regardless of stare decisis. So it's not an absolute, it's almost an absolute, but it's not an absolute. Okay, so a few things before I wrap up. There are some special rules for interpreting statutes. The first thing that a court tries to do is read the statute and determine what the plain meaning says. If a statute's ambiguous, then the court might use a variety of other techniques, like look at the act as a whole, look at the context of a statute, look at some canons of statutory interpretation, like, for example, if the statute says X, Y, and Z, it doesn't include A. And some courts look at legislative history, the Supreme Court less so as of recent years. The most valuable class I took in law school was administrative law, which I talk about in the next slide. Administrative agencies are the fourth branch of government, and they do an awful lot of interpreting of statutes. And so courts tend to defer to their interpretations of statutes per what's called the Chevron doctrine, but they only do so if the statute's unclear and if the agency gives a reasonable interpretation. So these last two principles, how courts interpret statutes and what's done with agency rules and regulations, sort of collide in the recent ACA case. But I have to apologize for saying that I don't think this case actually well illustrates these principles, but it does illustrate the principles. I think you'll understand what I say as I explain it more. So basically, the ACA said that tax credits were available when health insurance was purchased through an exchange established by the state. So the technical legal question in the case was, is a federal exchange an exchange established by the state? So in general, here we are interpreting a statute, right? So you look at the plain meaning. What does an exchange established by the state mean or sound like? Well, the court sort of glossed over that a little bit and said, well, let's look at those four words and put them in context of the statute as a whole. If you put them in the context of the statute as a whole, they seem ambiguous. But I think a good argument can be made, and why this case went all the way to the Supreme Court was, you know, an exchange established by the state doesn't necessarily sound like a state exchange. So that was part of the controversy in the case. The other part of the controversy in the case was this. The IRS had interpreted the words an exchange established by the state acting as an agency to include federal exchanges. So normally, the court would give Chevron deference to the agency. But the court said, in this case, we're not going to give deference because we don't think that that Congress meant to give the IRS essentially this much authority. So like I said, I try to use this example to illustrate the 2 points that agencies are generally deferred to and the plain language of statutes is usually relied on. But ironically, I think good arguments can be made that neither of these principles are well established in this case, but it's still an illustration nonetheless. So in the last 5 minutes I have remaining, I'll just make a couple of other interesting points about the judicial system. So the first one is, how do judges decide cases? The short version is they rely on briefs, which are documents that the parties and sometimes amici write that explain, you know, how the case should turn out. Judges also have judicial philosophies. I wrote down a couple on the screen. We could have a webinar an hour long on each of these philosophies. And how much any judges rely on any of them is up for question. The law school I went to espoused the ideal of legal realism, which is the idea that judges don't particularly care about what statutes say or what precedent is. What they care most about is outcomes, and they use the law and they use legal tools as a mechanism to get the outcomes they want. Cynical, perhaps, but I don't think it's always inaccurate. So amicus briefs are written by groups to sort of explain what the impact of a case will be nationally on a particular interest. And the question is, do courts or should courts rely on amicus briefs at all? And the short answer is that at least at the Supreme Court level, they often do. And last year, the SLC, for example, filed 12 amicus briefs. And Justice Scalia cited an amicus brief in one of his dissenting opinions. Justice Kennedy very likely relied on an SLC amicus brief in a concurring opinion. And these are just two examples. I mean, there are a million more of how the court relies on amicus briefs. So a bit about Marbury versus Madison. No sort of really accurate and thorough discussion of the Supreme Court or of the courts in general could ignore Marbury versus Madison. If you read the opinion, and I don't recommend you do, it may be hard to get this out of the opinion, but basically it establishes the concept of judicial review, which is the idea that the Supreme Court has the authority to declare a law unconstitutional. So skip to why is the Supreme Court so powerful? So the Supreme Court is a very powerful branch of government, and for a couple of reasons why. There's only 9 people on the court. None of them are elected. They're all appointed for life. They're somewhat homogeneous. They're not average in really any sense of the word. And they're never young, or at least not recently. They decide many of the most important decisions of the day. And as a practical matter, they're the final word on the U.S. Constitution. And equally as importantly, they get to pick and choose the issues they decide. Now, the next slide discusses when the Supreme Court is not so powerful. If the court interprets a statute in the way that Congress does not like, the Congress may rewrite that statute. And in fact, one of the last things President Bush did in office was sign the Americans with Disabilities Act Amendments Act, which basically overturned a whole bunch of Supreme Court precedent on the ADA. The first law that President Obama signed when he got into office was the Lilly Ledbetter Fair Pay Act, which overturned the Ledbetter decision issued by the Supreme Court. So the Supreme Court has a lot of authority, but not, as much as some might think. So you might wonder, how can I become a judge, or better yet, a justice? Well, the good news is, to become a federal judge, there are literally no qualifications. However, you have to be nominated by the President and confirmed by the Senate, which may be an impediment for most of us to become a judge. Now, to become a state judge, the practices vary so widely that it's beyond the scope of this presentation to discuss them. And I'll wrap up with 3 more quick points. One of the things that I was most intrigued by to learn in law school was that most cases settle, which I don't know how widely known that is. In the criminal arena, almost all cases settle. And there's a couple of reasons why. It's expensive to hire a lawyer, it's time consuming, and if you go before a judge, you have the possibility of losing everything, whereas if you settle, you can maybe, get sort of a compromise. The other thing that was very strongly emphasized at the law school I attended was that if you're involved in a dispute with someone you're going to have a continuing relationship with, it's much better to resolve it out of court than in court. And second to last slide, I talk about the role of an attorney general. This is basically the #1 lawyer for the state. On the slide, I wrote down some of the responsibilities of an attorney general that I got from the National Association of Attorneys General website. And my last slide before we turn to Paul is this. You may wonder, where can you find the law? Well, the law is more accessible now today than it's ever been. There are a couple of paid services, Lexis and Westlaw, that lawyers use. They're very expensive, but they get you quick, easy access to the law. Another reference is the State Law Library. I used the State Law Library all the time when I was in Wisconsin, and it's a free source available, I think, to anyone. And there's also great summaries on the law. Most people don't just sit around and read the law. If you want to know about the law, the best place to look are the documents I have listed on the slide. Treatises, law review articles, they're basically all just summaries of the law. So if there's a topic you want to learn about, I mean, on some level you have to read the law, but it's almost more valuable, especially as a non-lawyer, to just read about it using one of these documents. So, a minute over the time I designated for myself. I will now turn the conversation over to Paul Clement, who is going to talk about the role of the United States Supreme Court in our judicial system. Paul, go ahead.
Well, thank you, Lisa, and I'm happy to talk about the Supreme Court and how it works and what it does. I'll start by saying that I think the single most important fact to recognize about the Supreme Court is that its review of cases is discretionary. So Lisa was earlier talking about the judicial system in most states and certainly in the federal court system. And at the earlier levels of the judicial system, you typically have an appeal as of right. And in the federal court system, for example, if you lose in the trial court, you have an absolute right to take an appeal to the Court of Appeals. And they usually will have full briefing and argument and issue an opinion to decide the case. Even if they don't think your case is particularly meritorious, you still will get to brief it, and they will have some kind of summary disposition. That's not the case in the Supreme Court of the United States. And so the Supreme Court, as Lisa alluded to, is in the rather luxurious position of getting to decide which cases it hears each year on the merits. And it doesn't hear very many cases. It hears, in a typical term in the Roberts Court, it only hears about 70 cases a year on the merits, just 70. And that number is a low number, but I think it's really low when you consider that those 70 cases are picked out of a universe of over 10,000 cases where people file what are called petitions for certiorari, which are basically requests for the Supreme Court to grant review to hear a decision either out of a federal court of appeals or out of a state Supreme Court or state appellate court. So every year there are roughly 10,000 people who, in the words of the old slogan, want to take their case all the way to the Supreme Court of the United States. But every year out of that massive sea of 10,000 petitions, the court only accepts 70 cases, which it then hears, gets briefing on, and hears oral argument on, and issues a decision on the merits. So how does the court get from to 70? It goes through a process where it considers the petition. Most of the justices participate in something called the cert pool, which is a process where each of the petitions comes in, and one of the justices' law clerks, not one for each chamber, but one essentially for the whole court, puts together a memo summarizing the petition and offering a preliminary recommendation to the court as to how to handle the petition, and then that recommendation, that memo, goes to the other chambers. There's only one justice, Justice Alito, who doesn't participate in the certiorari pool, and he has his clerks look at all of the 10,000 petitions, at least in a cursory way, to try to get down to cases that the court should take. Eventually, some of the cases just takes one justice to put a case on what's called the discuss list, and that's the list of cases the court at least talks about at its conference about whether they want to take a case. The cases that make the discuss list, then the justices decide which cases to take, and it takes 4 votes, 4 justices, to hear a case on the merits. So what are they looking for when they're looking at those cases and deciding which of the 10,000 cases they want to hear on the merits? Well, the one thing they're actually not looking for, and I think this may be the hardest thing for people to understand about the court, but they're not looking for the decisions that seem really, really wrong. In fact, there's a word for that among the law clerks, and that is error correction. And other than, you'd think error correction would be exactly what appellate courts are for, but in reality, error correction is kind of a dirty word at the Supreme Court. It basically is the law clerk's way of saying that this case doesn't really have broader significance. It doesn't affect a lot of people who are not litigants to this case, but it's really just this particular client, this particular litigant, complaining that there was error in the Court of Appeals and they would like the Supreme Court to correct the error. And that's really not what the Supreme Court is about. I mean, ultimately, the Supreme Court, of the 70 cases it takes, it ends up reversing about 75% of those cases. So when it takes a case, more often than not, it ends up reversing. But it's not looking to take the cases principally to identify, for example, the 70 worst Court of Appeals decisions in a year or the 70 worst state Supreme Court decisions. What it's looking for are essentially 2 things, and ideally both of these things. One, there absolutely has to be an issue of federal law. It's not enough if there's an issue of state law, and it's not enough if there's just a fact-based controversy. There has to be some principle of federal law that is at stake, and then ideally it wants to find an issue of federal law where the courts have reached different conclusions. It's easiest to explain in the context of the federal system. There are, in the federal system, 12 regional circuit courts of appeals. There are 11 circuits that cover the country, and then a single court for the D.C. Circuit. If you have an issue about what a statute means, and the one circuit says that the law means X, and another circuit says that the law means Y, those are the kind of cases that the Supreme Court is most likely to take. They're also very likely to take cases where an act of Congress has been struck down as unconstitutional. And so to give you an example, some of you may have heard that last week the Supreme Court agreed to review the constitutionality or the permissibility of the government's policy for applying religious accommodations for the contraception mandate for religious nonprofits like the Little Sisters for the Poor. This is a case where you have the validity of a federal statute. It's not quite a constitutional issue, but the question in the cases is whether the federal government's policy, which is a nationwide policy, violates a federal statute called the Religious Freedom Restoration Act. And importantly, that's an issue where the federal courts of appeals had decided the case differently. A number of federal courts of appeals had said that the government's policy was fine, and then the Eighth Circuit Court of Appeals, which sits on the sort of far side of the Mississippi River from Wisconsin, the Eighth Circuit Court of Appeals said no, the federal government's accommodation policy for nonprofit religious groups is in conflict with the Religious Freedom Act and the policy is invalid. So that's the kind of case where when something like that happens, an important federal statute is being invalidated based on another federal statute, and the Court of Appeals have decided the issue differently. That's the case that the Supreme Court is most likely to hear. The Supreme Court takes about 2/3 of its cases, a little more coming out of the federal courts of appeals. It can also review cases from the state Supreme Courts or even from a state appellate court if a state Supreme Court declines discretionary review, though that happens relatively infrequently. But the important thing to remember is that even if a case is coming out of a state Supreme Court, the Supreme Court will only hear the issue if there is an issue of federal law. So if, for example, a state Supreme Court is interpreting the state constitution or a state statute, no matter how bad the Supreme Court might think that decision was, no matter how erroneous they would think that decision was, it wouldn't matter. They wouldn't take the case, and indeed they wouldn't even think that they had jurisdiction to hear the case. Because, as Lisa said earlier, the federal court system and the state court system are really parallel systems. The one place they meet is essentially in the Supreme Court of the United States, because it sits at the top of the pyramid and it can take cases from either the Federal Court of Appeals or the state Supreme Court, but it can only take cases from the state court system if there is a federal issue. So there are many of the most important cases that might be heard in a state Supreme Court will have no chance whatsoever of making their way to the Supreme Court of the United States. What is, of course, necessary is that issue of federal law. Sometimes it's an issue of federal constitutional law, so it doesn't just have to be a federal statute, but it does have to be an issue of federal law. The last thing I wanted to talk about is a little bit about how the court decides cases when they have these 70 cases. And then we'll leave time, hopefully, I think, for some questions, or I'll at least turn it back to Lisa. But in all events, with respect to the court's decision of cases, once they get their 70 cases, then things end up looking a little more like other courts because, as I say, the discretionary review feature is quite distinct. But on the 70 cases, they will have full briefing and argument. Because the Supreme Court is going to decide an issue of federal law, and at least until Congress revisits the issue, until Congress revisits the issue, the Supreme Court will have the final word on the issue. Supreme Court cases tend to attract a lot of amicus briefs, as Lisa was alluding to. Indeed, in some of the very high-profile cases, like the Affordable Care Act case or the marriage cases, there can be dozens and dozens of amicus briefs on each side. And that just underscores that the issues are of broad significance. But typically, the amici don't get to argue, only the parties get to argue. no matter how important the case is, the Supreme Court typically only schedules 1 hour for argument, and they tend to keep to those limits. So it's typically just 30 minutes aside to argue their case before the Supreme Court. The court will hear the case, and again, something that's a little different from other courts, the court will hear a case during its term. It hears arguments from October to April, and then it decides all of the merits cases it hears by the end of June of that year. So unlike some courts where you can argue a case and you really have very little idea how often, when you will get your decision, clients typically ask me, when will we hear from the Court of Appeals? And I usually have to answer, I don't know. It could really be any time. It's really up to the Court of Appeals. But in the Supreme Court, since they decide all of their cases that are argued in the term before they leave town for the summer, you know to a great certainty that they will decide their cases by the end of June of the year the case is argued. The court, although in a lot of the high-profile cases, is divided 5-4, and the court often divides among somewhat ideological lines, with Justice Kennedy typically being what is referred to as the swing vote. The reality is that in almost every term, the majority of the court's cases are decided either unanimously or by an 8-1 margin. So on many of the issues, even though they've divided the lower courts, the Supreme Court ends up treating them as if they are quite straightforward issues, and importantly, they don't divide along any kind of normal ideological lines. But there are anywhere from a handful to as many as 25 or 30% of the court's cases that are much more contentious and are decided by a 5-4 vote. And I think the percentages that are unanimous versus 5-4 votes varies from term to term. The term before last, at the end of the term, the Supreme Court had decided an unusual number of cases, over 50% of their cases, by a unanimous vote. And people commenting on that term were really focused on that and suggesting that the Supreme Court had reached some kind of a new consensus. After last term, with the Affordable Care Act case and the same-sex marriage case and a death penalty case, nobody was saying that. Nobody was talking about the consensus. Everyone was talking about the 5-4 decisions. But I do think the single most important thing to recognize is that term in, term out, there are always many, many decisions that divided the lower courts that nonetheless are decided unanimously by the Supreme Court. So even though you might get an impression from the highest profile cases that the Supreme Court is constantly dividing 5-4 along ideological lines, that's not really an accurate picture of the kind of typical cases before the court, where there's every bit as good a chance that the court will decide the case unanimously as there is that they will decide it by a more closely divided court. Well, there's certainly many, many other things that I could say about the Supreme Court of the United States, and I think we may have some time for some questions, but I did want to give you that overview of the Supreme Court, so thank you.
Thanks, Paul. That was a lot of information. I think our presentations combined might generate some questions. So if anyone would like to ask a question, you can type them on the in the box on the right-hand side that says questions and press send. So in the meantime, Paul, I'm going to ask you a question or two as we wait for questions. When I read your bio, when I put it together, I focused a lot on your role as a Solicitor General. And I am wondering if you could explain what the Solicitor General does and what its role is in the United States Supreme Court and in litigation generally.
Sure, Lisa. I'd be happy to talk about the role of the Solicitor General. The short answer is that the Solicitor General, excuse me, is the Supreme Court lawyer for the executive branch of the United States. And many cases that get to the Supreme Court are challenges to either federal statutes that the government and the federal government defends, or they are challenges to executive branch policies, which again are defended typically by lawyers from the Justice Department in the lower courts. When those cases get to the Supreme Court of the United States, the Solicitor General is the one lawyer who is designated to represent the interests of the United States in the Supreme Court of the United States. The Solicitor General's office also appears, even in cases that do not directly involve the federal government, often appears in cases as an amicus. And although most amici are not given argument time, the Solicitor General almost always gets argument time, even when the federal government isn't appearing as an amicus. So in a typical year, the Solicitor General and his office or her office will appear in about 80% of the Supreme Court's cases. And it's a very high number, obviously. Now, as you might expect, the Solicitor General personally doesn't handle all those arguments or all the work. But that said, the office is probably smaller than you might think, given the importance of the role of the office. There are really about 20 lawyers in the office, and there are about another 30 support staff in the office. But although it's one of the more, I think, significant offices, certainly in the Justice Department, it is also one of the smaller offices in the government. The lawyers from the Solicitor General's office will argue in front of the Supreme Court, so the Solicitor General himself or herself typically argues almost every sitting before the Supreme Court, but also will designate other lawyers in the office to argue important cases for the federal government. But although the Solicitor General's arguments in the Supreme Court are the most visible thing that the Solicitor General does, the Solicitor General also has a very important additional role, and that additional role is to oversee all of the government's litigation, and importantly is the Solicitor General is the person who has to approve an appeal when the government loses a case in the lower court. So if the lower court if the government loses a case in federal trial court and wants to appeal to the Court of Appeals, before that can happen, the agency or the lawyers who handled the case in the trial court have to get the approval of the Solicitor General. And that's important because it's one way in which the Justice Department in Washington tries to play a centralizing role in the various legal positions that are taken by lawyers across the country.
Okay, I have one other question as we wait to see if we get any other questions, and that is this. So there's been a lot of talk, particularly in Washington, about the fact that the Supreme Court is not perceived as being all that accessible of a branch of government. For example, there are no cameras in the courtroom, and maybe there's 148 seats or something that people can sit in to see an argument. And the transcript, I guess, now is available day of, but recordings aren't available for a week. As someone who frequently litigates cases, you have your own interests too, and perhaps your own opinions on whether you think, the court should be more open and more accessible. I mean, on one hand, there's nothing you can do about the fact that the building only has 148 seats, but cameras are at least, a possibility. So how do you come down on the cameras issue?
Well, Lisa, it's a great question, and at one level, it's obviously a decision I think that the justices have to make for themselves, and I don't think there's much. I think there's a lot of questions in other people's minds about whether there should be cameras in the courts. There doesn't seem to be much of a disagreement among the justices, and I mentioned before that there may be a public perception that many of the justices' decisions are 5-4, where in reality many of the decisions are unanimous. And I think the camera in the court's decision right now in the Supreme Court is probably unanimous. Even some justices like Justice Kagan, who before she became had suggested that she might be in favor of cameras in the court, has now publicly stated that she's sort of come around to the view of her colleagues that it would probably be a mistake and counterproductive for the institution. So, one observation is ultimately it's going to be, I think, for the Supreme Court to decide. I think if Congress tried to force the Supreme Court to have cameras in the court, it would open up a very interesting separation of powers case as to whether Congress actually could force the Supreme Court to do that. But barring that, I think it's going to be a decision by the Supreme Court, and I don't see it coming anytime soon. That said, I will say, that it's hard for me to see a really strong argument against having that kind of additional access to the court. It is a very important institution in our society. The court sort of recognizes the public interest at stake by issuing same-day transcripts and the like, and now same-week audio transcripts, and it just doesn't seem obvious to me why there is, something completely distinct about the cameras in the court from the perspective of sort of sharing the information with the public. And I also feel that at bottom, I do think that the Supreme Court is an impressive institution to see in action. The justices are always incredibly well prepared. They follow up on the advocates and don't sort of let the advocates sort of get away with any loose reasoning or the like. So I think at the end of the day, having cameras in the court would only enhance the Supreme Court's reputation. But whatever I think about it at the end of the day, it probably doesn't make any difference, because I think the court will make that decision for themselves, and for the time being, they seem quite set against having cameras in the court.
Well said. On that note, we're at 2:58, so I will wrap up. Thank you again, Paul, for joining us in this webinar. I enjoyed talking with you, and thank you to the audience for participating and for CSG for hosting. Have a great afternoon.